We are here to have an argument in our case number TX 190004, which is Swift versus the Department of Revenue. Counsel, each side has 20 minutes for argument. The appellant may reserve time for rebuttal. I would just ask that you keep that yourself. I know there's I don't see it right now, but a clock on the screen. Also, we are recording the argument, so if you could identify yourself and your client at the beginning of your argument, we would appreciate it. We conferenced the case yesterday and have read the briefs, so please keep that in mind when presenting your argument. And with that, let's begin. Mr. Galloway, you're recognized.
Thank you. May it please the court. I am Mike Galloway from Ryan Rapp, Underwood, and Pacheco. I'm representing the appellant, Swift Transportation. Also on the conference with us is my co-counsel, Ian McPherson. This is an appeal from the Arizona Tax Court dismissing this case for failure to state a claim for which relief could be granted. There are no undisputed facts. It is a legal issue. It is a case of statutory interpretation, and as you've seen, we have a situation of three statutes involving two very different taxes. It's the use fuel tax on the diesel fuel purchased by Swift, it's the use tax on that same fuel, and it's the exemption from use tax on that same fuel. We believe that all three of those apply at the same time, which is when Swift purchases the fuel right up front. There's a fourth statute that does come into play. It's 285612F. We believe this doesn't change anything that we're arguing. In fact, I think it affirms it. But it's been a part of this proceeding from the very beginning. I think it offers legislative intent, and so that's been in here also. I think it's pretty clear all of you are going to have to determine the legislature's intent with all of this. We, again, first and foremost, think that its intent is clear by the words that it used. I think we could end with that. But this is also a tax case, and tax cases, if they are ambiguous, are strictly construed against the taxing authorities. We don't have taxation by implication in this state. It needs to be clear and state its purpose, and that's in fact in the Arizona Constitution.
Okay,
is this a tax or an exemption from a tax?
Well, good question. Because it's been argued here that this case is about an exemption, and exemptions are strictly construed against the taxpayer. But there's no dispute about the exemption in this case. It applies or it doesn't apply. It's there. It's been quoted. That's all that's been said about it. Whether or not it applies is based on the two taxes we have here, the use tax and the use fuel tax, and how they apply and when they apply. We think it's very much a tax case, especially when you consider it's a mishmash that we've got with this thing. I think we're trying to argue how these taxes apply, and if they apply the way we say, then we get the exemption out of it.
I'm sorry, counsel. Let me try to pin you down on that. We understand. I think we all agree it's a tax case. I think Judge Morse was trying to make what I thought was a fairly uncontroversial point, which is the question is an exemption within the context of a tax case. Is that accurate?
Well, I think so. It's an odd case. I'm just saying that I think it is a tax case for purposes of how it's strictly construed. The ultimate result is or is not getting an exemption. But yes, that's probably a fair statement. The tax provisions are, though, what we're here talking about today.
Well, right. An exemption provision would be characterized as falling under that umbrella, right? As a tax provision. It's not like we're talking about an exemption that sort of applies externally into a tax code. But go ahead. Let's go to your set. You had mentioned that the plain words of the statute control. Which words and how are they plain?
Well, I'll answer that. But as you've seen, we have sort of a three-part process on what we believe. And the first is the Attorney General's opinion, which, although under old law, it's the same law, and it states exactly what we state and what we believe is correct.
I'm going to jump in here because how do you say that it's the same law? Because the Attorney General's opinion predates the whole, I think your word was mishmash, where you are applied, pay, apply for a refund and get the refund back. So how is it the same law?
Well, it's different numbers on the statutes, but it's still use tax exemption, and motor vehicle fuel. The only difference today is that diesel fuel is separated out from all of that. But as renumbered, it is the same legal issues. Now, you take
Is it the same text?
Yes.
No, it's not.
Well, it was a tax on motor vehicle fuel back in those days. Today, diesel fuel is taxed.
Yeah, but was it the same text with the same procedure of you pay, you are presumed subject to, then you can apply, the burden is upon you to show that it doesn't apply and you can get a refund? Was that the same?
Yes, I think it works exactly like that. It did before that and does that to this day, basically. I believe the Attorney General's opinion, and nobody's disputed that it's correct. It is different law, but it is exact same issues, and I believe the process is the same then and before then as it is to 2004 and to this day.
Well, let me ask you. Sorry to interrupt, Mr. Galloway. Isn't there one change, and that change is some form of express recognition of what I guess has been called an offset in the context of this case, which is the refund of the fuel tax and an offset of the use tax, and sort of the instruction guide, the statute that at least colors that process. That statute. Did that statute exist when Attorney General Corbin authored, or his committee authored, that opinion?
No, it didn't exist until 2004. But again, our position is it didn't change.
And why does it matter?
Well, it matters because it's been argued throughout this case that statute indicates the legislative intent to have one of the two taxes at issue apply, as opposed to neither of the taxes applying, as in the Attorney General's opinion. But I don't think that statute did anything of the sort. Let me put it this way. I think you can probably conclude in 2004 that the Attorney General's opinion entered into the discussion of that legislation. And it may or may not have been talked about that it needed to be fixed. Perhaps the agencies made some comment about that because they don't agree with it. Well, if you look at, in my opening brief, all of the proposed solutions that I've got for fixing it, and how you, going from the Attorney General's opinion to the statutory law, say, yes, one of the taxes applies, not, or one of them is exempt, not both of them. One of them does have to apply. You have to look at what I've got in there. And those are tax increases. That is the only way you can go from no taxes applying to one tax applying. And so I would speculate, back when this bill was going through, that the legislature did not want to do a tax increase. And they didn't, or they would have had to have done something like what I put in there. So it's to that extent, if nothing else, that I think the legislature indicated it was content with the Attorney General's opinion, his conclusion that neither of the taxes apply.
Let's go then. Sorry, counsel. Let's go then to subject to. What is subject to, right? Because that is a threshold issue that wouldn't even require this color, is the word I used, of the later statute. Why did the word subject to support your position?
Again, there are three taxes at issue: the use tax, the use fuel tax, and the use tax on use fuel, or exempting.
So why isn't your client subject to or not subject to a tax based on whether you are ultimately responsible or not responsible for that tax?
Well, I refer you to my briefing, but I mean, let me give you a simple example. In 3 hours, I go out and give $1,000 to one of my friends. Well, going back to all those esoteric cases I read in my first year of tax class in law school, that's income. And under the Internal Revenue's definition of gross income, it's income. So I think at that point, you've got income which is subject to tax. Now, my friend, when he filed his tax return, would somehow say, no, it's not taxable because it's a gift. But it's the same philosophy here. It's not just tax, it's tax jurisdiction and its ability for the agencies to do everything that they say. And again, refer to my briefing, but look what happens when you put the gas into your tank. It's presumed to be used on the highway. That you could do none of those things up front, where the distributors remitted into the Department of Transportation, if you didn't have a field, an area of law which made this type of thing subject to tax.
So counsel, you're saying that subject to has no pecuniary quality, that it is purely jurisdictional.
It later on has, yes, I'd say it's jurisdictional from the very beginning.
It has nothing to do with whether or not you actually have to pay anything.
Later on, that is determined, as with my friend who got the gift, or with SWIFT, because they down the road determined that some of that fuel was not used on the Arizona highway, so they filed for a refund of it. But you know, as far as subject to the tax, I mean, again, the minute they put gas in their tank, by all those provisions I put in there, they are subject to the tax. The distributors couldn't take that or charge them tax and remit it in if they weren't subject to the tax at that point. Liability, actual requirement to pay it, that comes later, I believe. So just going back to what I said again, I don't think in 2004 that the legislature wanted to have a tax increase to clarify this situation the way that the agencies believed that it applied. So they didn't, and that's why there's nothing in there. And that's why I believe the legislative language, you know, says over and over and over again, you net the use fuel tax as against the use tax as calculated under 42, calculated under the statutes. There's nothing in there, and I don't think they wanted anything in there which would indicate that there was something more than that, like a tax increase. And that's why I think that legislation is indicative that the thinking of the Attorney General opinion carries on through that. That was their intent.
Sorry to bother you, to interrupt. You know, if we're in a court, I do the same thing. It's kind of awkward. I just want to understand sort of the larger impact or meaning of your argument. And would you concede that under your interpretation, that there is a, I don't know if you call it sweeping or not, but certainly a fulsome tax exemption for diesel fuel whenever you have, actually, I guess it's just a tax exemption for diesel fuel that is purchased but ultimately not used on Arizona highways. Is that accurate, that there's just no tax on that?
That is how the used fuel tax applies. It is imposed
So
on
there's
fuel.
no tax on diesel fuel if it's not used to propel a motor vehicle on Arizona highway. Now, where is there any suggestion that or even if you can explain it to me how that makes sense, but you're not the legislature, but how does that make sense? So
Well,
we have a whole of tax-free diesel fuel.
Excuse me. There is nothing wrong with two exemptions from tax or exempt from two different taxes if the legislature says that it's okay. There's a classic example in the sales tax. If you're a charity and you want to sell things to make money, you go to the retailer and buy them. They're exempt from sales tax because they're sales for resale. Then when you turn around and sell them as a charity, they're also exempt because there's an exemption for that. The legislative, so I just go back to why, and that's because the Attorney General said so. And then when we had the chance to correct that in 2004, sorry, they didn't do it. Now, what is their motivation? Maybe Republican legislators don't want to raise taxes. You know, maybe they were more content with having no taxes apply to these big businesses than having one tax apply. But I'm just saying that I think the intent through what they didn't do in 2004 is pretty clear. And then when you follow it up with the department's regulation, which very conveniently a few months later says what you think they should have said and didn't, you know, I think it's all the more there.
When, if ever, has your client not paid use tax for diesel not used on roads?
I can't speak to anything prior to the current.
Then I'm confused because you keep acting as if there was a status quo prior to 2004 under the Attorney General's opinion in which your preferred or proffered version of the law applied. But my understanding, at least, and I'm widely open to correction on this, was that you're acting to change the way that it has been applied by the department going forward.
Well, I think it's been applied the way the department is applying it since the very beginning. I think that's what they believe.
Right, but your argument is that the legislature would have, if they didn't want to tax everything, so kept it going, but your client was paying taxes in 2004 on this fuel. It just changed the procedure in which the application for the refund would apply. Is that right?
As far as I don't know what was happening in 2004, but I know that they were probably going through the exact same process and getting used fuel refunds and being subject to use tax.
Okay, thank you.
At that point, they didn't.
You can go on. I don't want to use up your remainder of your time. You've only got 2 minutes left.
All right. All right. Well, then I would just say then the second part of that legislation is the fact that they still did come out with a formula. And if you look at the legislative history, you can see at least what is said is that there were apparently problems with that formula. And so the legislature went about fixing those and codifying it. Now, the department has asked in its briefing, you know, why would the legislature enact a formula which wouldn't be used, since under our argument it would be zero tax due every time? Well, I just submit that's a straw man because the formula is going to be used down the road by the Department of Transportation or Revenue. They're going to apply it the way they see fit. Now,
Council, just you know, you only have 1:51 left. So if you want to preserve, usually I wouldn't do this, but if you want to preserve any for rebuttal, if you would stop that clock, I'm sorry.
All right. Well, I will, sir. I'll take your suggestion and I'll reserve the rest of rebuttal.
Okay. All right. Let's go to counsel for the Department of Revenue, Ms. Steigen.
Good morning. This is Kim Seigan, and I represent the Arizona Department of Revenue. The legislature created a very simple system here. If you buy diesel or used fuel that is used to propel a motor vehicle on a state highway, then the fuel is subject to the fuel tax under Title 28. And if the fuel is not used to propel a motor vehicle, then it's subject to the Title 42 use tax. Now, to ensure that no fuel used to propel a motor vehicle escapes the fuel tax, the legislature provided that the fuel tax is paid in advance at a high level by the supplier for the customer.
Well, counsel, why isn't subject to a jurisdictional limitation rather than?
Okay, because I can tell you exactly, because the legislature did not intend what you are subject to be set in stone. And that's the major flaw in Swift's argument, is that the fuel tax statutes contemplate that being subject to the fuel tax is conditional. So, for example, the definition of use under Section 28560136, it defines use as basically the placing of the fuel in a vehicle, and this is the key, unless the operator of the vehicle establishes to the satisfaction of the director that the fuel was consumed for a purpose other than to propel a motor vehicle on a highway in the state. And then there's also a presumption found in Section 285615A. That statute creates a presumption that all used fuel received in tending receptacle on a motor vehicle from which fuel is supplied to propel the vehicle is consumed in propelling the vehicle on the highway in the state. But the statute provides that the presumption applies until the contrary is established by competent proof under rules and procedures that the director adopts. So when a taxpayer successfully rebuts the presumption.
Well, counsel, it's subject to defined in the state. It's not, is it?
And that's why you have to look at the context of
okay. We agree it's not defined.
Correct.
And I understand your explanation and argument for why it deals with something other than jurisdiction. But is that sort of where we need to go, which is sort of reading the statute as a whole in order to understand that, no, this isn't subject to ellipsis, fill in the blank, subject matter it's not some sort of jurisdictional tool. It is, in fact, the ultimate responsibility of having to pay the tax. In order to get there, I think your argument would be that you have to sort of look at this mishmash, to use Mr. Galloway's words, and read them as a whole.
I would agree with you. Yeah, I mean, what it all comes down to is legislative intent. What did the legislature intend to do here? Did it intend to tax fuel once and only once, or did it intend this loophole or windfall and exempt all diesel fuel from all tax? You just don't get a break from all tax simply because the supplier makes this advance payment simply for administrative convenience and to prevent the evasion of taxes. And SWIFT can't come up with any possible logical reasoning why the legislature would exempt use or diesel fuel altogether. Certainly not based on the plain language of the statute. I mean, they have to go through this, really convoluted, hyper-technical explanation, and there's nothing in the legislative history indicating that the legislature intended to tax used fuel and diesel fuel altogether.
Well, I think in tax law it might be definitional that we have to go through loops but let me ask you another question. I'm not so sure this is clear. This doesn't strike me as crystal clear. And so my question to you is, can you provide me other examples in which your client does this collect in advance and let's revisit based on actual conduct or actual use, I guess is the proper word. And at that point, we'll exchange, do an offset and change things up, and you'll be held to this tax and we'll take back that tax. Can you give me an example or other examples with citation to statute where that's the process?
Well, let me clarify something. My client is not ADOT. My client is the Department of Revenue. So
Right.
I can't give you an example where ADOT collects any kind of a tax in advance. So no, I can't. And I don't feel comfortable speaking on behalf of ADOT.
Okay. No. That's always a good practice. So you're not aware of this. I don't want to say novel because I don't know if it's novel, but interesting procedural twist in any other context with the Department of Revenue.
No, I'm not.
Okay. Continue. I'm sorry.
Well, again, I just want to reiterate that basically what it all comes down to is legislative intent, and I don't really have a whole lot more to add, other than, like I said, what SWIFT is subject to. Like I said before, it's not set in stone, and that it's a rebuttable presumption, and when a taxpayer successfully rebuts that presumption by applying for a refund under Section 2856.12, then it establishes its entitlement to a fuel tax refund and its liability for use tax. So, like I said, be subject to fuel tax. It's conditional, and that's how the legislature intended it. And all of Swift's mumbo jumbo about how you can't change being liable for fuel tax is clearly wrong under the statutes. Obviously, you can change it and apply for a fuel tax refund.
Counsel, you would concede, I think, that your office, the Attorney General, authored, putting aside what the state of the law was, a pretty clear opinion exactly contrary to the department's current position. Is that correct?
No, I don't. We said it was legally unsound on page 25 of our answering brief. We don't agree with it, and I think
if you agree with it, I'm sorry if I'm just trying to. You understand that that's there.
I do, and I find it really ironic that that Swift is arguing that this AG opinion from 40 years ago, which is based on statutes that have clearly changed, is persuasive, but a rule that the department developed that has gone through a public notice and comment procedure and has gone through the governor's regular review process, that rule, according to Swift, should be given no weight whatsoever. But again, it's your job as a court to determine what the legislature intended here. So it simply doesn't really matter what the AG opinion says. And like I said, under the current fuel statutes, it's clearly wrong.
Let me interrupt now because you just said the law has clearly changed, and your opponent earlier told me no, the law is exactly the same. 5612, or at least my reading of the statutes, is that 5612F was added in 2004, and there wasn't a predecessor that matched up with that statute. Am I incorrect on that?
Not that I am aware of, but again, that statute didn't change anything as far as being subject to the tax. It's simply an offset mechanism. And
but as far as the AG's opinion in 1984 was concerned, it didn't have that formal statutory mechanism to consider in its analysis. Isn't that right?
This is correct.
Okay, thank you.
I don't really have anything else more to add unless you all have any questions for me.
Well, I do want to follow up one more then, because you said clearly different. What in your opinion is clearly different about the statutory system that we're operating under now as opposed to the Attorney General's office of 1984?
Well, I think as I mentioned before, the presumptions, the presumption in Section 28560136, which defines use as the placing of the fuel into a receptacle, but it qualifies that presumption by saying unless the operator of the vehicle establishes to the satisfaction of the director that the fuel was consumed for a purpose other than to propel a motor vehicle. So the legislature has created this rebuttable presumption, and it's not set in stone. And so I'm not sure exactly how the whole scheme worked 40 years ago, but like I said, you have this rebuttable presumption that the legislature created, and so once the legislature rebuts that presumption by applying for a refund under Section 2856.12, then it's entitled to a refund, and then it's subject to the Title 42 use tax. And if you do nothing to rebut that presumption that the fuel is used to propel a motor vehicle, the department certainly isn't going to come after the taxpayer for use tax, because the taxpayer paid and subject to the fuel tax, as long as it doesn't rebut that presumption.
Counsel, let me ask you, there's one thing that I just didn't really get out of the briefing, and which is it goes to precisely the issue you framed, which is the fuel tax. We all understand is at least partially to compensate the state for the use of its highways. Is that correct?
Yes.
Okay. The use tax doesn't seem to have a mission statement set forth in the statute that explains to us why it exists and what its purpose is. Can you tell me what the purpose of the use tax is?
Well, I think it's similar to any other tax, just like the transaction privilege tax, corporate income tax, individual tax. It's to go into the state fund. It's just to fund services in general to the state. That's where it goes. It goes into the state's general fund to be used for purposes in general. Whereas motor fuel taxes are special. We know that because under the Arizona Constitution, Section 9, Article 14, taxes that are imposed on motor fuel or relating to the use, operation, or license fees of motor vehicles have to go into a special fund, the Highway User Road Fund, which is used for roadway purposes. And so the legislature here wanted to ensure that those taxes go into the correct fund. That whole Arizona Constitution provision came about because the Hayden-Cartwright Act, which conditioned federal funding on these kind of provisions, and so the legislature enacted this whole system to ensure that no fuel escapes the fuel tax provision and goes into the correct fund.
Okay, so let me give you a little bit more information on what my question is. Okay, so we have a case, for instance, Quest versus Department of Revenue, 2005, Court of Appeals, 210 Areas 223, which either states or suggests that the use tax is a gap filler. That's its purpose, which is to prevent consumers from avoiding Arizona's, in this case, transaction privilege tax by making their purchase in other states subject to the use tax. Have you ever heard that the use tax fills that role as a gap filler?
Yes.
Okay, so that's what I'm looking for.
Right, but it applies in other situations as well. So, for example, in the section that imposes the use tax, ARS Section 42, 51, 55B, it talks about the
here it would be serving that exact purpose. You have a gap that is filled by a.
Right.
Okay, so. I didn't see that argument raised, and can you color that a little bit more, or do you agree with it, or?
Right. Well, I do. And for example, I was going to point out another one where it fills in the gap, and that's, like I said, under ARS Section 42, 51, 55B. It says this tax imposed by the section applies to any purchaser that purchased tangible personal property for resale, but subsequently uses or consumes the property. So in that case, the taxpayer would have gotten a break on the property, would have purchased it because it would have provided a resale exemption. But then if it subsequently uses it for its own purposes, then it has to pay use tax at that time. So that's just another example where it's a gap filler.
So in this case, not to put words in your mouth, but the use tax is just doing its job.
Correct. I would agree with that.
Okay. Anything more, counsel?
No, that's it. That's all I have, unless you have any other questions for me.
Okay, thank you.
None for
Ms.
me.
Oh, I'm sorry. Yeah, Judge Perkins?
I'm good, thank you.
Okay. Thank you, Ms. Saigan. And let's go back to Mr. Galloway.
All right, I think, okay. Thank you, I see my time. Okay, well, very quickly, to Judge Morse's point, the AG did not look at a formal formula in 1981, but they looked at the exact same thing. I think you just read into that and you see that the department did informally what it's now doing under the statute. So I don't think anything's changed in that regard. All right, the concept of subject to is not conditional, okay? Taxes are you come under the tax system when you come under the tax system. It's not a question of it's conditional, it's a condition of later determining on a tax return, like all of you might do to see if you get a refund or have to pay. Later on, you make a determination of what you owe. But the subject to part is when the process comes into place at the very beginning and you fall under that.
I was with you until right then, because when I think of taxes and us paying our income tax to the federal government, I don't think of the rate I'm subject to as the amount that is withheld. I think of the rate I'm subject to being the amount I'm actually required to pay net of all refunds. So why would that help your argument, Mr. Galloway?
Well, you're subject to the tax. Later on,
yeah, but if I'm subject to, for some income, I'm subject to a 10% rate. For some, I'm subject to a 25% rate, and some a 33% rate. So why is that different?
Well, none of those rates could come into play unless you were subject to the tax in the first place. But I'm just saying, as far as the use fuel tax goes, you do not become subject to the tax when it's finally determined on a tax return that you pay X or Y. You're subject to it at the very beginning when you put it in your fuel tank and the distributors take it out and you're presumed to be taxable. That's my time.
Okay, well, counsel, I want to thank you both really for working with us and for your time and your argument.
Thank you.
We will take it under advisement. Everyone, please stay healthy, and we will have a decision out in due course. Thank you.
Thank you.